Yes, Mr. McGee.
My lady,
I think.
Sorry, yes, indeed.
Yes.
I don't intend to take over long on this ground. I probably won't be done within 13 minutes, as my learned leader suggested I wouldn't be yesterday.
Not going to rise to the challenge, then.
No, I thought about it, but decided it was unwise. We maintain all the arguments in our skeleton and all of the reasoning of the Upper Tribunal and the FTT. And fundamentally, we submit that the UT was right for the reasons it gave, and therefore that the FTT was right for the reasons it gave. For your note, that's the FTT decision at paragraphs 169 to 193, core pages 162 to 166, and the Upper Tribunal decision at paragraphs 106 to 117, the core pages 93 to 96. Okay. I do, however, have three important points I ought to make. First, we heard nothing yesterday from my learned friend on the point raised by the Upper Tribunal that my learned friend's case on this ground doesn't actually entitle him to succeed because of the academic nature of it, given the findings of the FTT. And this arises in the context of the First Tier Tribunal's finding at 193, core 165.
Do you want us to turn that up?
That's probably why. It's probably sensible, please.
Sorry, can you give me the page?
Yes, page 165.
Thank you.
Thank you.
On this basis, we do not consider that the arrangements operated by Mainpay during the relevant period were a genuine attempt to reimburse subsistence expenses.
Sorry, paragraph?
Paragraph 193.
That's actually 166, but...
Oh, I'm sorry.
We've got that. Thank you. On this basis, yes, I'll have it. Thank you.
Were a genuine attempt to reimburse subsistence expenses actually incurred.
So that, you say, is a finding of fact that...
It hasn't been challenged. And my learned friend accepted yesterday that a reasonable estimate can, even on his case, only be used where it is reasonable to use an estimate. I think that was at several occasions, in particular at 12:09 p.m. yesterday. If you've got in front of you the receipt, it's not reasonable for you to use another number. And again at about 12:24 p.m, was it reasonable for you to do what you've done? My ladies, my lord, I submit that whatever else, it cannot be reasonable to use an estimate where it does not represent a genuine attempt to get to, in short, the right numbers. This is a point made by the Upper Tribunal in their decision at paragraph 116 at core 96. I'm not going to invite you to turn it up at the moment, but fundamentally what they say is they recite the FTT's finding of fact and that there's no challenge to it. And then they say that it's not apparent what purpose would be served by a decision on these propositions in light of that finding. And we say that's absolutely right. I should also, in that context, also briefly note for the court that if the court is minded to refer to the petrol example raised by my Lord Justice Arnold, there's a statutory quirk with petrol, but it does work if it's train tickets. I can go through and explain the statutory quirk.
No, I don't think you need to. We'll give it a miss.
Excellent. That gets me through another 2 pages quicker.
No, we don't want to deprive you. Does that bring you down to 13 minutes?
We'll see. My learned friend seeks to address the point raised by the Upper Tribunal at paragraphs 73 to 74 of his skeleton, which I make as being pages 34 of the core bundle. But we say that that's a flawed attempt to seek to confine that factual finding of the FTT, against which, as the Upper Tribunal notes, there is no challenge. And I'm sorry to flip you around. If you could then turn back to the FTT decision, and again, that's now at 165 to 166. And if I could invite the court to read briefly the paragraphs 190 to 193. You've already looked at 193. And so it's true that the fact that the FTT bases that finding on is a failure to pay regard to whether any expenses was incurred. That's clearly the on this basis that 193 starts with. But the FTT was clearly entitled, as it did, to take that failure into account when it's deciding, as it is at the end of 193, whether looked at as a whole, the arrangements were a genuine attempt to reimburse subsistence expenses. And so, for that reason, we say that there's nothing in ground 2 that can assist the appellant in any substantive way, even leaving aside ground 1. Second, I ought to give a brief explanation of the Revenue and Customs brief document. That was the document we were looking at yesterday at supplementary page 2, and the overview section there. And so what that overview section does is it effectively sets out the historical position that this brief is then correcting or amending. Because when the dispensation system was brought in, as the brief explains, the revenue would only agree a dispensation, so the ability to pay scale rates rather than actual expenses, on the basis of, in particular, a sampling exercise in order to ensure that the dispensations were the fair ones, that the numbers were right. And you can see that at paragraph 1 to 2 of the overview section. But as they then go on, they recognise that such a sampling exercise could be burdensome and expensive. And so for employers who've applied for and are granted a dispensation, which has a number of safeguards built into the dispensation system, including in particular the need for it to be monitored by the taxpayer, the revenue say in this notice that these rates are the ones which we will accept. And that these scale rates are tied to the dispensation is made clear in the brief. They're not freestanding scale rates. And that's the first question in the question and answer, page 3, if you just turn over the page, where it says, what do you have to do if you want to pay scale rates to your employees? Answer, you should apply to HMRC for a dispensation. And then it goes on about how you do that. You complete a form, tick against the appropriate statement. And then picking it up on the 4th line, by ticking this box, you would be merely notifying HMRC that you intend paying HMRC's benchmark scale rates for day subsistence, and that you have adequate management processes in place to ensure that payments are only made where all the qualifying conditions are met. And as you'd expect, companies who wish to pay their employees less can, of course, do so. That's the reference for that is at the top of that page. In the middle of the first line, an employer could pay less than this rate if it wants to do so. The brief also makes clear that if companies wish to pay more than these scale rates, they've got 2 options. And looking at the bottom of page 3, the top of page 4, at the 4th question, do employers have to use the benchmark scale rates? And the 2 options that are set out are that the employers, if they don't want to, can reimburse their actual expenditure, so therefore having to have the appropriate standards of proof and evidence for that, or they can apply to agree a scale rate appropriate for their business needs in a dispensation, a tailored or bespoke dispensation. And as the note explains, there you would have to do a sampling exercise to show that the higher rates are in line with what the employees typically spend on subsistence, and then agree that rate with the revenue. And third, these are 2 related points, which my ladies and my lord I think may already have from the exchanges yesterday with my learned friend. The first is that the mere fact that the revenue can prospectively be satisfied that payments at a certain level by certain employers who have sufficient checks in place would not cause any tax liability to be engaged, does not entitle an employer effectively to adopt a parallel or sort of self-created system absent such a dispensation. The FDT was right at paragraphs 186 to 187 for your note to identify that the process of an officer being satisfied and so on engages the care and management and the general discretions and administrative...
Sorry, can you give me the paragraph?
Sorry, excuse me, paragraphs 186 to 187.
Thank you.
Engages those care and management powers. And clearly there is some discretion or leeway as to what an officer needs in order to be satisfied. And originally the approach taken was the rigorous sampling exercise that we've looked at. At about 12:15 yesterday, my learned friend submitted that you have to remember this is applying to the employer. This is the employer who's going to be operating this. And the whole point of this, and the dispensation, and providing the advisory scale rates, is the administrative impracticality of doing that, i.e. processing the actual expenses, for potentially thousands of employees and potentially thousands of receipts. My learned friend is entirely right when he says that. But that's why Parliament has enacted this dispensation procedure with its safeguards, and it's not a justification for entitling an employer to adopt a parallel, self-created scheme without those safeguards. And finally, in that regard, it is also not a justification to adopt a parallel, self-created scheme providing for round sum allowances, that in respect of particular items, a taxpayer might be able to fill out his tax return honestly and properly, or be able to satisfy the burden on them to disprove an assessment by reference to a genuine estimate for a particular item of expenditure. They're just completely different questions. So unless I can assist the court any further, that, at slightly more than 13 minutes, are my submissions on ground 2, and I hand back to my leader to deal with causation.
No, thank you very much indeed. That was extremely clear. Yes, back to you. Ground 3, please.
Yes, indeed. And ground 3, for third and final ground, which has probably occupied more time than the other 2 grounds put together, even though it only relates to 2 of the years at issue. It has narrowed from what it was before the FTT and Upper Tribunal, because now the only question is whether the Upper Tribunal, and previously the FTT, erred in holding that HMRC had established the necessary causal link between the alleged carelessness and loss of tax. If it isn't already clear, HMRC's case is based on section 118 subsection 5 and effectively stands or falls on whether this subsection does what HMRC submitted does, which is what the Upper Tribunal accepted, or whether it indeed does something else, or nothing at all.
Just take us back to the reference to 1185. I haven't
Yes,
managed to
that
find my
is-
way at all around the bundles, I'm afraid.
It is Authorities Bundle, page 31.
Oh, right.
So we're reading the first
Right,
volume.
yeah.
Thank you. And you will have the point already that the reason we're looking at this is that for 2 of the years at issue, HMRC were relying on an extended time limit under section 36, and that can only be relied on where the taxpayer is alleged to have acted carelessly in bringing about the loss of tax. Now, for the purposes of your note, the issue is dealt with by the Upper Tribunal at paragraphs 144 to 162, which are at core bundle pages 102 to 106. That includes at paragraph 145 on page 103, where the FTT dealt with this issue in paragraphs 212 to 215. And the FTT reference is core bundle 168 to 169. And so the issue, to put it in quite simple terms, is did the Upper Tribunal set out the correct and workable test in relation to causation, which it then proceeded to apply to the facts before it? And I will turn to what the Upper Tribunal says, but broadly, as you can see, we rely on the reasons it gave, and submitted made no error of law in setting out its conclusions on that issue.
The key question is whether the FTT made an error of law.
Precisely. And as I've said, the Upper Tribunal does refer to what the FTT said and says that it came to the right conclusion. Now, just to address a few points in my learned friend's skeleton, there's a point made in his skeleton argument, paragraph 80, which is page 35 of the core bundle. This is where it refers to, well, that according to HMRC, it was deliberate that they did not plead or prove a case, though if reasonable care had been taken, the loss of tax in the tax return would have been avoided. And there's a reference there to my skeleton argument in the Upper Tribunal. That is in the supplementary bundle at page 125. And it is responding, that paragraph 82, to a point being made against HMRC as to whether or not the FTT was making a case for HMRC, which HMRC had not made themselves. And you can see what it says there, that HMRC did not consider they needed to run a case, that the appellant should have taken further advice, what that advice would have said, and what it would have led the appellant to do. And it responds to the appellant's skeleton argument there, paragraph 142. And so to put it another way, HMRC completely accept that they bear the burden of proving carelessness, including causation, but what they do not accept is that they had to do what the appellant considered they needed to in order to plead and prove their case on this issue. Now, the appellant's submissions on this in its skeleton argument are set out in 4 sections, as we've seen, and they start with a section A, which is just before paragraph 82, core bundle, page 36.
So, just before we get into the detail, can we just get some basics clear? So, you have just confirmed what you say in your skeleton argument, namely you don't dispute the need to prove causation. And I assume that there's no dispute either that that means factual causation.
Right. So if that means, are we talking about legal causation? The answer is no. And when it's talking about factual causation, it may be that we're looking at this in slightly different terms, because I understand my learned friend when he refers to factual causation to mean but for causation.
There's two separate questions. First of all, are we talking factual causation? You confirmed that we are, as I expected. Secondly, there's the question of what test one applies for factual causation. And as discussed with Elisabeth yesterday, the normal test in the law, it's not the only possible one, but the normal one is but for.
Yes.
So are you disputing use of the but for test?
Yes, we are.
All
Because
right.
we say that the test is what you look at is what does subsection 5 of section 118 say. It says the loss has to be brought about carelessly, and those words then have to be applied to the facts which you have before you.
Right. Well,
And
given that you've been clear that you dispute the application of the but-for test, could you articulate for us the test of factual for causation that you are asking us to apply?
So what we say is that it is basically, there has to be, if a taxpayer has fallen below the standard of the prudent and reasonable taxpayer in their position, so has failed to take reasonable care, that failure should lead, it is important that it is necessary for that failure to lead to the loss of tax.
It is necessary.
Necessary, in other words, well, yes, there has to be a connection.
Okay.
And
So
I was
I'm
going
just
to go
trying
on to this. We're not arguing for carelessness in the abstract, in the sense. And what I mean by carelessness in the abstract is, example, I think, I'm not sure.
Well, that's clear, because as soon as you accept that there is a requirement of causation, then carelessness in the abstract goes out the window.
Precisely, yes. And if we needed to look at that, you will have seen yesterday you were referred to magic carpets in the FDT, which in turn refers to a previous decision called Bayliss. And Bayliss makes that very precise point. For reference, it's at page 1511 of the authorities bundle, where it talks about, well, this taxpayer has rather sloppy documentation, it's not perfect, but we're not concerned with that they haven't got nice documents, there are things which are a bit wrong with them, it doesn't mean the documents are a sham, but that isn't the relevant type of carelessness we're looking at. There does have to be a connection. I mean, I think in a sense...
All right, but I need to come back to my question.
Yes,
because
indeed.
you still haven't articulated the test you're applying, and I'm a little bit puzzled. Because I would assume that the revenue is not going to be arguing that but-for is over-inclusive, because it's a pretty wide test. It's not hard to say that the but-for test is satisfied. So that suggests to me that you are going to argue that it's under-inclusive for this purpose. And why would it be under-inclusive?
No, I think, but for... What I would say is maybe not so much under or over-exclusive, it's just not very helpful. In the sense that when we're looking at, and I think Bella
I'm sorry, but I'm instantly going to come back on
Yes.
that. It's routinely applied in the courts of this country, day out in and day out in negligence cases.
Indeed, my lord, yes.
And why is this any different?
Well, it's in the sense that because when we're looking at in negligence, what is the cause of your loss? Is a simple, and if it were not for this thing, you would not have suffered this loss. Simple as that. It is in the paradigm case, for example. Let us look at this case here. We have a taxpayer who enters into an arrangement. HMRC say your contract does not work. You have further tax to pay. There has been a loss. The taxpayer says, well, you can't assess me, you're out of time. HMRC say, no, you've been careless, you failed to take reasonable care. Taxpayer says, but I took advice. And at that point, we then say, I took advice, and therefore I do meet the standard of a reasonable taxpayer. Well, at that point, HMRC come along and then look at the advice and say, but it is not of the standard which it ought to have been. I think I've made a point which hasn't really answered your question, my lord.
No, it hasn't at all.
No,
it hasn't at
so
all.
I will
But
go
because
back
because there are at least three different questions.
Yes.
Firstly, what's the test? Secondly, what counterfactuals does one need to consider when applying that test? And thirdly, how does the evidential burden relate to the legal burden and the circumstances in which it can shift, given that it's accepted by Mr. Firth that it can shift? Now, I suspect that the reality of this case is the debate is all about question 2, and what counterfactuals need to be considered,
Yes.
and upon what evidential basis. But you can't have an intelligent discussion about question 2 before you've had a clear answer to question 1, which is what is the legal test?
Yes.
And at the moment, I'm still baffled as to what legal test you are arguing for.
Right. So the legal test is, if we look at the wording of section 1185, it says that the loss of sorry, I'm just looking for my reference here. I'm in the wrong place. A loss of technical situation is brought about carelessly by a person of the person fails to take reasonable care to avoid bringing about that loss of situation. And as the Upper Tribunal said, the focus is on the word avoid. What did the taxpayer do to avoid bringing about that situation? Now, if the taxpayer says, I took competent advice, that might be it. If the taxpayer didn't take any action to avoid the loss, we say, well, then there is a connection between the failure to take action and the loss. So, when we say the counterfactuals, I think the problem...
Yeah, but you still haven't given me an answer to question 1. What is the test if it's not but for?
The test is there a connection? And that is what the Upper Tribunal ended up saying as well, between the actions or inactions taken by the taxpayer and the loss which has arisen. And that requires an inquiry into the actions taken by the taxpayer.
So how does this differ from a but-for test?
I think the main issue HMRC have is that the position which seems to have arisen after Bella Figuera, or at least it's understood to have arisen after Bella Figuera, that is for HMRC to prove the various counterfactuals. Well, if you had gone off and taken other competent advice, for example, this loss would not have arisen. And the complication arises from the fact that it's HMRC which bear the burden of proof on carelessness. And so if
it's no different to a negligence claim. In a negligence claim, common law, the claimant bears the burden of proving all the elements of the tort: duty of care, breach, loss, causation.
Yes, but the problem here is when it is HMRC issuing assessments and penalties, which are based on fault of the taxpayer.
To be sure.
It does raise the question as to how far do HMRC have to go to prove their case? I think that is the problem which arises when we say, well, it's just but for causation and you apply it in the same way as in tort. And so that's where...
I think the real problem that you're concerned about is not about the legal test, with respect. I think the problem you're concerned about is my questions 2 and 3. I think that, and that's a perfectly legitimate concern. But at the moment, I'm really struggling to see how the legal test you're propounding differs in any intelligible and workable way from a but-for test.
Well, it may well be that, I think to an extent we do accept that there is a but-for test in a very loose way, in the sense there has to always be a connection. And it may well be, my lord, that you are quite right, that the issue is mainly, at least from the revenue's point of view, as to what do you do, well, actually, this is the point the Upper Tribunal made. What do you do to prove that there is a connection? Now, the Upper Tribunal does explain what it considers needs to be done. It says it depends on the facts. You see what the taxpayer's done, and have they taken action to avoid bringing about the loss? Which is why we then come back to section 118.
Yeah, but okay, this leads to the next question. Is it your submission that section 118, subsection 5, changed the law?
Well, I was going to come on to this because it isn't, we would say it's fair to say that it's not entirely clear what the law was previously, even based on the cases we've been taken to prior to 2010. Because at the most, all they say is that they use the word caused, but no one actually goes on to consider, well, what does that mean?
Well, caused is definitely different from having a connection.
Well, yes. It's been caused.
Because connection
That
is definitely gives the HMRC a lot more slack than having to prove that it caused, was it the carelessness led and was responsible for the loss.
it was responsible, was attributable to, which is the language we see previously as well. But when, I think the point I'm making is, we were taken to two cases, Johnson and McGuckian. Both of them use the word caused and leave it at that. And basically say, well, actually, if it may be worth it just looking at Johnson, which we were taken to yesterday. And this is authorities, it starts at authority 765. And the relevant passage you were taken to yesterday is the one on page 770 between paragraphs B and C.
Yep.
And that's based wholly on the use of the word caused. And what it makes there is that, and this is a case, we don't need to go into the slightly racy details because the taxpayer was mildly concerned about what evidence the inspector had relied on in raising the assessments. But as the High Court says there, once the Crown has found that there has been neglect, it enables them to make the assessments and to make assessments for the purpose of making good the loss of tax, thereby caused in cases where the assessments would otherwise be out of time, and then the onus shifts back to the taxpayer to displace those assessments. And that's as far as it goes.
Why would one not understand that? I appreciate your point. It's not spelled out.
No.
But when one sees the judgment of a High Court judge using the word caused without further explanation, surely the assumption is that he's talking about factual causation on the ordinary test.
That indeed, my lord, might be right. I think the more of the point is that this is stated in Johnson Scott. You see similar statements in McGuckian, but the actual question of causation isn't debated in any case prior to 2010.
Okay, I'm sure you're right about that, but I come back to the question. Are you suggesting that Section 1185 change the law, and specifically change the law with regard to the requirement of causation?
Well, what we would say is that it introduces, it's almost a kind of deeming, because what it says is that in order to show a person is treated as having acted carelessly if they fail to take action to avoid bringing about the loss of tax. So once if you do not satisfy that
On the
test,
face of it, it seems to be a definition of what is meant by carelessly.
or indeed brought about carelessly, which is because, as you will have seen yesterday, that there were changes to the penalty regime as well, which brought in.
So Section 118 is a definition section.
Yes, it is.
So what phrase is defined here? Is it a loss of tax is brought about carelessly, or a situation is brought about carelessly? I mean, those phrases that are used elsewhere in the legislation, so I don't have your knowledge of the legislation. I think the first question is, what phrase or phrases is subsection 5 defining?
I would say it's defining brought about carelessly.
Right.
And you can also see, if you actually look on the same page.
So is that a phrase that's used elsewhere? Well, that is used elsewhere.
So it's used in section 36, which is
Yeah.
time limits. It's used in section 29, which is the provision enabling HMRC to make assessments out of time.
Okay, so brought about carelessly used in, section 36 and section 39.
29.
29, sorry,
Yes.
my fault. All right, so the job that this subsection is doing is to define that phrase for the purposes of the Act.
Indeed, and actually, if we just look on the same page, you see subsection 6 about when a loss of tax or situation is brought about by an inaccuracy, and how that's treated as having that is also treated as having been brought about carelessly. So that's included.
Yeah.
And subsection 7 talks about brought about deliberately.
So you've got as a result of used in subsection 7, and then subsection 6 is a deeming provision, isn't it?
It is.
Shall be treated for the purposes of this Act as having been brought about carelessly by that person, and that refers you back to the language of subsection 5.
Yes, it does.
So subsection 5 is quite a telling you how you work out whether or not a loss of tax has been brought about carelessly, and it's only brought about carelessly for the purposes of the Act if the person has taken reasonable care to avoid bringing about that loss of situation.
Yes, that is what it says, and that is what we say it applies. And if it is saying something which is different from the but-for causation test as understood by, say, a tort lawyer, then yes, it does change the law.
Yeah, so it's a special test for the purposes of that phrase when used in this Act.
Yes, my lady, that is what we say.
Okay.
And on that, you have my learned friend submissions. Well, if you're making that change, how come it wasn't referred to in the explanatory notes, etc.?
Yeah.
And as I say, well, that's because causation really wasn't a focus of litigation prior to that. And equally, the changes which were made to the penalties provisions, again, you'll have seen yesterday that there was a reference to how you have new terms there. You have terms such as due to and leads to, which again, we accept that there has to be a link between carelessness, the conduct alleged, and the loss of tax. But that is as far as it goes under this legislation. And that is dealt with in Delphi derivatives, which I will come on to.
But this might well be a narrower test than but-for causation, because the sole focus of this test is whether or not the person has taken reasonable care to avoid bringing about the loss.
Well, yes.
And it doesn't matter, you would say, whether it in fact brought about the loss, just the mere fact that they were careless and there was a loss will do.
Well, if they didn't take any action to avoid it.
Yes, exactly.
And I think, and I do point out that, again, I'll say it again, that it's not carelessness in some abstract manner. You still have to tie it to the loss of tax.
Yeah, but in answer to my lady's question, your argument is that the test is broader than but-for, not narrower.
Well, in a sense, yes.
That's why you argue for connection.
We do argue for connection, because otherwise you do end up with the odd situation of being someone who's not very good with documents and ending up with a tax assessment, for example, which isn't
Quite strange, given how broad the but-for test is, because but for the individuals behind Mr. First Client's being born, there wouldn't have been a tax loss. You know, it goes that wide.
Yes, but I think, my lord,
is why it's thought to be generally over-inclusive rather than under-inclusive, save in the rare situations like concurrent causes. So it's a little surprising to be faced with an argument that, oh no, but for is insufficient.
well, it's more to the point. I think it's the.
Well, it's more that but for is different.
It's slightly different, and then it's if it isn't already obvious, HMRC are more concerned with the evidential points as to what a but-for test would entail in terms of proof. Whereas subsection 5 puts the focus on what the taxpayer did.
Or didn't do.
Or indeed didn't do. I was going to take you to Delphi, but I'll...
Sure.
I will do that in a minute, because before I do that, I wanted to, just to close off this point about what was the position prior to 2010, because my learned friend has referred to the Upper Tribunal's decision in Hargreaves as well, which he says shows that HMRC had to show the loss was caused in a specified way prior to the introduction of subsection 5. And just very briefly on this, it's in the authorities bundle at page 1350. Now this is, starts at page, the relevant passage starts at page 1372. And you can see that at paragraph sub 4, paragraph 75, where again there is a challenge to whether or not his the situation, capital letters, was attributable to his negligence, and particularly if he'd sought further advice, it would have remained proper for him to claim to be non-resident. This was a residence case. Now, just at the top of paragraph 77, in the first line, you can see that the Upper Tribunal upheld the FTT's conclusion that Mr. Hargreaves had been negligent in failing to obtain further advice. And paragraph 78, the FTT considered whether or not the FTT had done enough to displace that case, and said, well, it's not enough to, the fact he didn't give evidence isn't enough to satisfy whether or not the accusations of negligence were established. And then paragraph 80, which we've seen. And broadly, the Upper Tribunal upholds the FTT's decision that he had been in breach of his duty by failing to take further advice, but then goes on to consider what would have happened if he had obtained further advice, and considers what that advice would have said and what would have happened. Now, this is one point about this case is it is concerned with the pre-2008 legislation, but the case itself is decided in 2022, and it's decided after Bella Figura, and the tribunal judge at the time, Judge Jonathan Richards, as he then was, is the same as in that case. And what's more, there's no reference to Atherton. And so, my submission in relation to this case would be that, again, you accept that the loss needs to be attributable to the negligence, but don't accept that you should speculate what the advice would have said if it had been sought.
But the conclusion is a fairly straightforward one in 81. The FTT made no finding on the causation question.
Yes, and it says, well, if it hadn't been for its conclusion on the other points, it would have held that there was an error of law in that point. But that is on the basis that it didn't go on to consider what the advice would have been and so on, if he had sought further advice, which is the point I take issue with.
Is there an appeal in that case?
This is 2022. There is another Court of Appeal decision involving Mr. Hargreaves, which was before this. That was on the preliminary issue, which you'll have seen referred to in my skeleton, which was on a slightly different point, which is if you find carelessness in relation to one aspect of a tax return, does that open up the entire return? And in that case, the Court of Appeal said
it might have been that that particular conclusion wasn't susceptible of appeal because the overall result was that in the Upper Tribunal, Mr. Hargreaves lost.
Yes, yes, indeed.
So HMRC couldn't have appealed. I'm assuming he didn't.
As far as I'm aware, he didn't.
Yep. All right, but can I be clear? What is your submission? Are you submitting that this is wrong?
Yeah, I'm submitting it is wrong on the basis that it started speculating about what Mr. Hargreaves could have done and what that advice would have been.
But what's wrong with it? I mean, in any negligence case where a breach of duty is alleged, when you come to the question of causation, you've got to consider what would have happened in the counterfactual.
Well, and that's where we run into difficulty.
But why?
Because how do HMRC then go about proving the counterfactual, particularly in a complicated case? Now, for example, you were taken yesterday to Altunis, and it said, well, actually, this isn't very difficult at all, because it's a specialist tribunal. And that was another case which involved the pre-2007 penalty legislation. And you will recall, this is a section, it starts on page 1553. And this is the point you were taken to yesterday. So causation, again, it's on the this is on section 95, which is the predecessor penalty legislation. Paragraph 198, there's reference to Bella Figuera. And then paragraph 201, you see my submission that HMRC burden of proof cannot extend to requiring production of witnesses as to what advice would hypothetically have been given. And tribunal agrees with that. And then in 202, it says, well, we accept HMRC must show the negligence caused the loss of tax, and then comes to its own conclusion as to what any advice would have said. But my point on that is actually a relatively clear case. In that case, it's quite easy for the tribunal to come up to that conclusion, because this is a case only on the penalty. Mr. Altunis had already conceded the scheme didn't work. There was evidence before the tribunal, you can see in paragraph 203, that his subsequent advisors had accepted.
What I'm trying to understand at the moment is what you say is wrong legally with this approach, because at the moment it seems to me to be a perfectly coherent and workable approach. Because first of all, it interprets causation in a very straightforward way, factual causation on a normal basis. Secondly, accepts you don't have to produce witnesses, which goes to my question 3.
Yes.
And it gives a very straightforward analysis of the relevant counterfactual. Now, I take your point that the relevant counterfactual in tax cases may be a bit more complicated than it was in that case. But we have to pronounce a test that is applicable in all cases.
Indeed, yes, my lord. So,
and at the moment, I'm struggling to see what the alternative is to the approach that was adopted in Altunis, which seems to me to be perfectly workable.
well, the issue is Altunis, it's a straightforward case where it's easy enough to see what the counterfactual would have been. The problem arises in more complicated cases where, say, there would be a conflict between professional advisors at the time. And then that comes down to a question, well, in those circumstances, could HMRC ever prove that someone had acted carelessly?
Maybe not.
Well, in fact, that is, there is another FTT decision called Strachan, which I don't think it's in the bundle. It might be referred to in Mainpay by the Upper Tribunal itself. But well, then that's the problem. So if, say, someone can be shown to have failed to take reasonable care, they didn't take advice, but then it becomes a question of, well, what would that advice have said, and would someone have acted upon that advice, and what were the other, and so on. It then becomes a question of, where do you stop?
But why is that a problem? Let's suppose the factual scenario is such that at the relevant time, on the relevant issue, there was a genuine difference in a professional opinion as to what the correct approach was. Now, on any orthodox understanding of lack of reasonable care, someone who, in those circumstances, takes one of the two available routes is not demonstrating any lack of care, because there is a respectable body of professional opinion, to quote the Bolam test, that's one of your options. And what on earth is wrong with concluding that in those circumstances HMRC doesn't prove its case?
And I think, and that is the point then, does that mean HMRC then have to produce an expert witness?
No. It means you fail because there was no negligence. And what's wrong with that?
Well, I think this is the point where, for example, Delphi and Magic Carpets, which you've been referred to, are cases where there is, well, on the taxpayer's case, there is a difference of opinion. And in that, the causation argument's arisen slightly differently, because all the taxpayer says there was a settled view that PAYE deductions were allowable. HMRC say, well, we disagree with that view. And we have grappled with that issue in that case. Causation issue arises slightly differently there, though, because in Delphi, HMRC alleged carelessness on the basis that while the taxpayer did act carefully, starting off by obtaining advice from its accountant, it then failed to follow that advice, which was take a second opinion. And so the question is, what was the when it's...
That's wholly different from my lord's example.
Yes.
Because that's the case where step one, tick, took advice, but the advice was get a second opinion and didn't. There's your carelessness.
Yes.
That's completely different.
But then the response which comes back from the taxpayer is, but well, even if we had, there would have been no loss. And so at the moment, the debate in Delphi is focusing on the question is, do we go and look into that question? Or do we just focus on the fact that you didn't do what your accountant told you to do? I'm not asking you to express an opinion on that. That's the Upper Tribunal have heard full argument on that point. And one of the points which I make in Delphi, because again, it comes down to, well, do we need to look into what that further advice would have been? And there is, well, what Section 1185 is doing is saying, what did you do? If
we haven't been shown Delphi yet, so it might. Would
I've
it help
look
to look
it
at
now.
that?
Yeah, well, yes, it probably will, because I'm just referring to obliquely. So it's at 1558. That's the head note. If you could read the head note between D to G, the rest of it to deal with. Well, actually, no, you'll have to read the whole of it, I'm afraid.
The whole of the holding.
On 1558 and then 1559.
Okay. Give us a moment.
I think there is also no question about deliberate behaviour, but that's only one sentence at the very end.
So they don't seem to have had any trouble in applying the but-for test.
Well, actually, the tribunal considers that it's not a but-for test.
That's not what the head note says. Is the head note wrong?
Well, what it says, it didn't consider.
Oh, I'm sorry, I'm misreading it. No,
But-for
you're right. It's my fault for misreading it. Yes,
Right.
thank you for the correction.
And the question as to what it considers the test to be.
Oh, but they say there's a nexus. So
Yes.
what is the nexus if it's not but-for?
Well, you find that at page 1610 in paragraph 164.
Sorry, page what?
1610.
Thank you. Paragraph.
It's a section starts paragraph 164. And saying, right, we now have to consider what does the phrase due to mean. And you can see it then goes on to refer to the change in the structure wording in 165. And then in 166, it refers to what it considers the nexus to be, attribution.
What does that mean?
Well, it says, in this the inaccuracy can be accounted for by a mode of behaviour which is characterised as failure to take reasonable care.
But then it says attribution in the sense of because of an or account or owing to.
Yes.
But then goes on, it doesn't equate to the kind of nexus of causation opposite to tort. So it's not but for.
Yes, that's what. And the reason I'm showing this to you is because just to show that this isn't the you were shown magic carpets as support for that seems to be suggesting but for. But here we have Delta, which is on the same scheme and saying it's not. And that's why both those cases have gone to the Upper Tribunal.
On this point.
On causation, there is more going on.
What test are they applying? I just don't understand it.
Nexus. may not be the same as connection.
Well, nexus, connection,
But what do these
attribution.
words mean, if not but for?
Well, they say specifically, the FTT
Well, it
says
says-
specifically it's not but for. It's lesser.
Yes. You do see it's that whole section 164 all the way down to 171.
Seems to me to be a recipe for chaos.
That's why we're here, because back in March I was explaining Mainpay in Delphi, and here I am now explaining Delphi and Mainpay. But one of the points in Delphi is, again, if we take the focus of what did that taxpayer do, they obtained advice from their accountant, so far so careful, but then didn't follow that advice and getting a second opinion. And so the question is, well, what could have happened if they'd taken that advice? And if, say, the second opinion had come along and endorsed the scheme, then even if HMRC, don't like the scheme, it would be very difficult for HMRC to mount an argument that that was careless, or that there's any element of carelessness.
Yeah, but couldn't you? What's wrong with inquiring what the second opinion would have said? Because if the second opinion, properly done, would have said, this is high risk, probably you're going to be caught by the revenue, then that's one answer. And if a properly done second opinion would have said, this is fine, then you get a different answer. What's wrong with that?
Because, all right, this is fine, and then it's a question of, well...
Because we all know in this world that it sometimes happens that experienced tax counsel, properly instructed, opines that a scheme will be successful, but subsequently it turns out, once it's tested in court, that it's not successful.
Yes.
But that's not negligence.
No.
But
Yes,
by contrast, we also know that there are cases where advice is taken and tax counsel says this is high risk, but the client says, well, I'm going to give it a go anyway.
Indeed.
And those are two rather different scenarios.
Yes, but then the question is, if the client's obtained the high risk, if we've got the position where the taxpayer hasn't obtained any advice, and then we say, well...
Yeah, but then you keep on saying if they haven't taken any advice. And this all brings us into questions 2 and 3, which have nothing to do with but for. It's to do with what's the counterfactual and what's the evidential burden.
Yes.
And there's a simple answer to this. I'm not saying this is necessarily right, but one answer to it is to say, well, for a client who's never taken advice, then the evidential burden is on them to show what proper advice would have been.
Yes, indeed, my lord. That would be correct. It would be for them to
So
say.
why is that not a simple way forward?
It may well be a simple way forward. Maybe we got there in the end, but I think there is a risk in this case of sort of looking at the statutory wording and saying, well, this is what the statute has said in the TMA, in section 118, and that's what it says you need to do to show, well, this is what tells us the taxpayer has been careless, and then going off and applying that to particular facts, and having this question of, and is this informed by, say, a causation test taken from the wider general law? I think the position I would end up in is that it is possible in practical terms you may end up in the same position, but you get there from a different route, in the sense that in a tax appeal, you're going to be applying the statutory test, brought about. It may well involve the same kind of inquiry as a but-for test, at least on the question 1, I'd say.
Yeah, but see, what is concerning me, as I'm sure you've appreciated, is that the whole point of this ground of appeal is that this court needs to articulate a workable test that can be applied in a range of cases without too much difficulty.
Indeed, yes.
And there is an advantage in that in applying familiar, well-established concepts in the law, such as but-for. And of course, you're absolutely right. We are concerned here with a very specific provision in a tax statute against a general background of the way the tax system operates, and therefore one has to be sensitive to that, of course. But at the moment, it seems to me to be preferable to apply familiar concepts that are easily applied than to introduce some nebulous concept of connection where nobody knows what it means when you come to apply it.
Well, just on that last point, I would say that the Upper Tribunal didn't have a difficulty in explaining how you would apply what the test they've come up with.
Well, what they really said was the FTT hadn't made any error.
Indeed, yes, on the particular facts of this case, but it is looking at the question slightly more widely. The argument was expanded in front of it, and it said, right, well, the easy question is saying HMRC have to prove this, the harder question is what do you have to do? And then it says, well, it depends on the facts, and then puts forward some examples. But perhaps this may help articulate the question that suppose you had 2 taxpayers. We were both about to enter into the same transaction. One takes advice and the other doesn't. And the one who takes advice is basically would satisfy the requirement of having acted carefully. They took action to avoid bringing about the loss of tax, albeit their scheme does not work. But the one who doesn't take advice, if they can say, well, actually, even if I had taken advice, it would have made no difference, would seem to benefit from the same outcome. And that then seems to be taking the focus away from whether or not a taxpayer has been careful or careless.
It's a concentration on the question of causation.
Yes.
Because you say it's wrong to treat the taxpayer who takes no advice. Even if the advice would have been, this is fine, to equate that taxpayer with the taxpayer who actually does take the advice. But why not? Because from a causation point of view, it's identical.
But it's the question about what, whether or not the taxpayer has been careful, whether or not they've been careless at the first stage.
Rather than putting it rhetorically, let me ask you the direct question. Is it your submission that the law should be that the taxpayer who does not take advice, even if the advice properly done would have been that this is fine, should be in a worse position than the taxpayer who actually does take the advice and gets that advice?
Yes, it is my submission, and I base that on what 1185 says about...
So that is throwing causation out the window.
Well, but that may well be, but that is the test under subsection 5 then, about what did you do to avoid the failure of bringing about the loss of tax?
What if he says, well, my mate got the advice?
And I think that then comes to a question slightly before that. Well, your mate, was it reasonable for you to have relied on your mate's advice? Or that advice, or I knew there was advice floating around. And again, it keeps the focus on what the taxpayer did.
But as I understand it, your position is, I was just looking at paragraph 247 in Delphi, which although of course it relates to different sections, says in turn, you reject the appellant's submission on causation as derived from the concept of negligence.
Yes.
We reject the submission that seek to establish a causal link in the but-for sense. And that you would endorse that finding.
Well, yes. Unsurprisingly, because I was acting for HMRC.
Understood.
But yes,
arguments have moved on. We're First Tier Tribunal, and we're now in the Court of Appeal.
We are indeed. And what we would say, though, is that the decision in Delphi, you'll have seen it came out in... Delphi doesn't refer to FTT Mainpay, where the argument is dealt with quite briefly. But what I would say is that Delphi FTT does foreshadow what the Upper Tribunal then says in Mainpay.
So can I come back to the two cases I was putting to you in my last question? So in those two cases, it's plain that the failure to take advice does not cause the loss. Now, I appreciate you are arguing for connection, but in what sense is the loss connected with the failure to take advice?
Well, sorry, so the failure to take advice does not cause the loss because the advice would have...
Because the advice, if taken, would have been, this is all fine. So the result would have been the same in terms of what goes in the tax return.
And I think...
Well, your submission seems to be that the language of 1185 supports a different approach, which is that that's not you're not asking about causation. You're asking about so the situation is brought about carelessly if the person has failed to take reasonable care to avoid bringing about that loss. So your case is all you have to show is that the person failed to take reasonable care to avoid bringing about the loss.
Yes, my lady, it is, because my case is always focusing on what the taxpayer did or did not do.
So on that basis, all you have to show is lack of care.
Yes.
Well,
you don't have to show anything more at all.
But the lack of care, but not in the abstract sense. So I'm afraid we do come back to those words which my Lord has taken issue with. But it is that just being a careless person, for example, or not doing anything which has an effect on your tax position isn't going to be enough.
So this is a way of penalising people who don't take reasonable care.
Well, in a sense, well, yes, it is.
Even if it hasn't resulted in a loss.
Well, the reason, because that is, you were taken to the consultation yesterday, and there was a focus in that, in particular, for example, that one of the reasons all these provisions are now being changed in relation to penalties and assessments and so on was to, not my words, encourage compliant behaviour. And the whole point, because of course we have a system of self-assessment, it is on the taxpayer to put forward an accurate return. And find it, because I didn't.
But would it been easy, if that had been the parliamentary intention, it would be easy to say that the time limit can be extended wherever the tax return has been filled in with a lack of care. There need to be no reference to any loss of tax at all.
But then that's suggesting that the system is interested in lack of care where there has been no loss of tax.
Yes, because what was being put to you was the suggestion that the effect of your argument is that this is penalising lack of care regardless of any loss.
Oh, sorry. No, lack of care which does result in the wrong amount of tax being paid. So it is.
There has to be causation, doesn't there? We go round in circles.
We are going to...
Well, I'm not sure how productive it is if we go round one more time.
Well, no,
I think we're very
really
clear what your argument is.
I would hope so. I think, if nothing else, I have set it out at length in the skeleton. You'll have seen we do rely on... what I will say are the key planks of my argument. So section 118 sub 5. You will have seen the approach in Atherton.
Yes.
Now, the appellant says, well, Atherton's wrong. It didn't consider the explanatory notes. It didn't consider Hicks, for example, I don't. Well, on the explanatory notes, you have my submission. No one was really thinking about causation. On Hicks, Hicks is again another case which refers to how the loss of tax ought to be brought about. We don't really have an issue with Hicks. So we say Atherton's correct. You will have seen, I think, the main concern on HMRC's part is broadly trying to keep this sensible, bearing in mind it has to apply to everyone. With a simple, workable test, we submit that the Upper Tribunal got that test right. In particular, when it's looking at, well, did the FTT make the right decision? Had HMRC done enough, both on a matter of pleading and proving?
All right, can I ask you this question, which is a completely different question, because on one view, the question we're being asked doesn't matter on the facts of this case. Because on one view, you could say, whatever the test is, it's satisfied on these facts.
That, I would suggest, well, I would be tempted to make that submission, but I don't think that would be the right submission to make, in the sense that, well, whatever it is, we do have to say, well, what we say is the test is given by the statutory language and it's satisfied. Now, if this court were to say, well, there is another test, but it doesn't matter on these findings, it was nevertheless satisfied, bearing in mind that the appellant has conceded that it will take reasonable.
Let's explore this question just briefly. See, one way of looking at this case is the taxpayer was negligent when it did the 2010 contracts. It didn't take proper advice for the reasons explained by the FTT. But the proposition that it would have made any difference if they had taken proper advice is belied by the fact that when they redid it in 2013, the result is the same.
Yes, my lord, yes. So you could say, well, that's enough of an evidential basis for the tribunal to have come to its conclusion.
Indeed.
But on the other hand...
So why is that not a very simple answer on the facts of this case?
On the facts of this case, I think the question is, do we need to go any further for HMRC to then say, well, actually, this is what the understanding was in relation to, say, overarching contracts at that time, and this is what you needed to have done, and if you had done this, well, you would have to have done this extra thing. You'll have seen there's a bit of discussion in the...
But then the follow-up question is this. Why did they do no better in 2013? Answer, because if we're brutally honest about it, it's because they didn't want to take the necessary steps to ensure that they had an overarching contract of employment. It was a choice.
Yes, I'm finding it. Yes, well, that may well be, again, that may well be the answer, that they didn't, but that's then asking us to speculate as to why they didn't do various things in 2013. Now, of course, the appellant's case is that it did take reasonable care by going to its advisor, Mr. Hugo, who had then gone to a law firm for advice. But the findings of the tribunal were that those actions did not amount to reasonable care.
But there's a further strand, isn't there, which is to do with just making automatic assumptions about the expenses that have been incurred without doing any kind of checking. How does that feed in, or does it not feed in at all at this stage?
I think I'm just looking at what the FTT said. Well, I think that comes at a second stage, because the question was, well, it was on the taxpayers to ensure that the contract was the type of contract which would enable the expenses to be deducted.
Yeah.
Yeah, but you see, my latest question highlights what I was trying to get at, because reasonable care is not just about advice you take from professionals, it's about what you yourself do as a taxpayer. And if you don't take reasonable care to put in place, on the facts of this case, an overarching employment contract, then the question of what the advice would have been in 2010 is actually, in a sense, academic, because it doesn't matter. In other words, let's assume, in favour of Mainpay, that even if they got better quality advice in 2010, the result would have been the same as in 2013. Well, it doesn't matter. Because what did they do in 2013 when they had better quality advice? Answer, they still didn't take the necessary steps.
Yes, indeed, my lord. I don't disagree with that. but that's not really how the FTT approached the question. It's looking...
well, exactly. And that's really what I was driving at. Because suppose that was the view we took of the matter, what would be the correct course? Because it seems to me, procedurally speaking, that might lead to the conclusion that the FTT erred in law, but it reached the right conclusion, and therefore we should remake the decision, but to the same effect.
Yes, my lord. I was just going to return. I have been reminded by my energy.
Oh, sorry. Just while we're on that theme, sorry to interrupt. One possible approach might be that the FTT erred in law, but any such error is immaterial on the facts.
Well, you would say. Well, we say the FTT did not err.
No. I know. We're making an assumption.
Yes. I was just going to say on this point about my lady's point about, well, what about the fact that they used the wrong rates?
Yeah.
Now, this is a submission which was rejected by the FTT. You can see this, it's paragraph 206.
Right.
Of the FTT?
Yes, page 167. So it's...
Chowdhury referred to the fact Mainpay didn't have any advice.
After the publication of the
Yep.
brief, which we've seen. And so this is part of the earlier section, which is dealing with failure to take reasonable care.
Okay.
And then at 207, you see the FTT stating its conclusion and then giving its reasons for the conclusion,
Yep.
which are at 208 to 211. And I think we have referred to this obliquely, and you will have seen this. It's 212 to 213, which deals with the pleading and causation point.
The point being made by the FTT there is that that's not a point. That's not the case you relied on. Last sentence of 206.
So that goes back to the pleading.
Yeah.
Of course, this is all to do with the pleadings.
Yeah.
And in fact, you can see that the pleading point, again, we're sort of going backwards, I apologise, but that's dealt with first on page 166. From 198.
Yeah, just coming back to what I was looking at before, I mean, an alternative way of looking at it is actually, when it comes to the crunch, there's nothing wrong with what the FTT says, because maybe one of the key paragraphs, well, the key paragraphs on one view are 212 and 213.
Yes.
Because in 212 they say, failure to take reasonable care to ensure that the contract was an overarching contract of employment. That's what caused the loss of tax. And then 213, failure to take care to ensure that the contract in question was an overarching contract of employment. And the advantage of that way of phrasing it is it's not just about what advice you take, it's also about what you do when you get the advice.
Yes, yes.
And so, on one view, that's the correct. They're asking themselves the correct question, including causation, and giving the correct answer,
Yes.
or at any rate, an answer that was open to.
Precisely, Mara. We say that there is no error there. We should also, you do see paragraph 214, which then the appellant took issue with later on. It says, well, these are other things it could have done, for example. But it's already reached its conclusion in 212, 213.
And it says in 213, led directly to the loss of tax.
Yeah, but
and that is where the debate between
exactly
the bench and the bar, in the form of you,
but the
has
advantage
focused.
of the phraseology in 212 and 213 is that it stands up when you propose the counterfactual by analogy with 2013.
It does.
Because in 2013, they still failed to take reasonable care to ensure that the contract was an overarching contract of employment. So you avoid the question of, well, HMRC haven't proved what advice would have been given.
Yes, because again, and I would say that the FTC is again focusing on what did this taxpayer do?
Exactly.
Anything else?
I'm just looking at the messages from those behind me and remotely, and and whether Mr. McGee wants to. May I take a moment, please?
Yes.
But I think I
Deal
have
with
covered.
the cyber tuck on your gown.
Indeed. My ladies, my lord, I am told that in a very roundabout way I have made all the submissions.
Well, Miss Chowdhury, you couldn't have been straightforward given the contribution from the bench, which you've dealt with in your normal, courteous and exemplary manner, for which we're very grateful.
Well, I'm very grateful for that, but I would say that if, as far as I think I have dealt with all the points in the skeleton and hopefully have answered all the questions which have been put, and on that basis, those are the Commissioner's submissions.
Thank you. Anything else? Thank you. Anything in reply?
Yes, my lady. Given that it's fresh in the court's mind, I propose to start with causation. I showed you yesterday that HMRC's own consultation document repeatedly says the loss of tax must arise as a result of the culpable behaviour. So the suggestion that the HMRC might have understood the law prior to 2010 in the way they now suggest the law should be understood as a result of the 2008 changes seems wrong, because their own consultation documents repeatedly says must be as a result of the culpable behaviour. You can also see it if I'm not going to take you there, but there's references in the manuals at the back of the authorities' bundles, but HMRC's own manuals, current ones, talk about the loss of tax must be caused deliberately or carelessly, for example, 1928. The suggestion, which we heard, that the earlier cases don't debate the meaning of causation is simply because, well, what debate was it possible to have? causation means causation. Everyone agreed and understood what it meant. There's no need for debate. The only higher authority the HMRC reserves that takes any different view is Atherton. You've heard my submissions on that. Every other authority, Bellafigura, Hicks, Hargreaves, Johnson and Scott, McGuckian, they all know what it's talking about. It's factual causation. And whilst HMRC maybe couldn't have appealed Hargreaves, they could certainly have appealed Bellafigura. They lost that case. Sorry, suggest it's wrong. We'll have a look. Yes, page 1189, the assessments are set aside on the basis they're out of time.
HMRC's appeal is allowed.
The assessments are set aside on the basis they're out of time. I mean, you can appeal that decision because it's a decision that the assessments are out of time.
And subsection 2, the scheme sanction charge still stood as a valid assessment.
Well, we know we take what your
sure
overarching point is.
And when you look at 1185, well, I've shown you all the build up to it, and I've shown you Cobalt data in the Supreme Court confirming that when you're looking at these things, it's important to bear in mind the context, the background, and the purpose. And you get that purpose very clearly from the explanatory notes. Now, I don't propose to take you back to it, you have it from yesterday, but it says quite clearly this corresponds to the definition of careless in Schedule 24 of FA 2000. Very clear that this is simply defining careless. And in fact, if you look at the full wording of 1185, the question of the reference to bringing about is maintained in the explanation. It keeps that concept there. It's not defining that concept, it's defining careless. And if there's any doubt about it, it's put beyond doubt by looking at the previous materials.
Can I just ask you a hypothetical question?
Of course, my lady.
Please, Mr. If we were to think that the language of Section 1185 was clear, could we reach a different result based on the explanatory notes?
Of course you can, my lady. The authorities are clear that you can find ambiguity not just in a literal reading, but also in the background materials which may give rise to it.
No, I didn't. My question wasn't if we find 1185 ambiguous, can we look at the explanatory notes? My question was, if we think the language is clear, can the explanatory notes displace a clear meaning?
Well, my answer to that is yes, because ambiguity can arise not just from a literal reading, but also a reading based on the purpose. And my submission is it's certainly the 1185 doesn't support HMRC. You need to read it on the basis it's simply defining careless. So when it says a loss of tax is brought about carelessly, it's simply telling you what careless means. And then it retains the concept of bringing about in the explanation. It says when you fail to take a reasonable care to avoid bringing it about. The concept of bringing about or brought about is retained. And it's well, you've seen Bellafigura and Hicks explicitly say, well, this is just providing an explanation of what careless means. You've got those clear authorities. And as I said, no higher authority other than Atherton that suggests otherwise, and Atherton just simply didn't consider these points in the detail that we've considered them. It was odd that you were taken to Delphi, because Delphi did not concern 1185. Did not even concern, I think, the period of time when 1185 was enforced, which is 2010 onwards. It instead concerned the due to wording in FA 2007, and there is no equivalent. There is no equivalent to 1185 in FA 2007 because Schedule 24 of FA 2007 already says careless means failure to take reasonable care. So it doesn't need an extra definition. And that makes my learned friend's reliance on Delphi even more surprising, because her submission is logically that she can sidestep or wash out the requirement for causation even in relation to a test such as due to. Even where the legislation says, is the loss of tax, the inaccuracy, due to the carelessness, Delphi says, on her reading, that's not a causation test, which is astonishing. I mean, it really is astonishing. If we could please turn up Delphi and just look at that section my learned friend showed you, and I'll just make some brief points. It's 1610. And the court has already noted at 166, when trying to explain, so it's paragraph 166 on page 1611. The court's already noted that when trying to explain what its test is, the tribunal ends up saying, well, is whether the loss of tax or inaccuracy is because of, on account of, or owing to, which is no different to factual causation. It's not describing any different test. And then you look at the reasons. I mean, I accept that the tribunal does say in terms, well, we don't think this is the negligence test, but then you look for reasons. You look for reasons as to why it's not that test, and with respect to the tribunal, they're not there. I mean, you can see it. 168, it starts talking about specificity. And it talks about needing to be the proximate immediate cause. I mean, possibly the tribunal simply rejecting legal causation, but that's not how this paragraph begins. It's with respect. It doesn't refer to any of the sort of higher authorities on causation, which I've shown you the Supreme Court ones. It doesn't engage with any of the authorities I've shown you in relation to the tax test, Bellafigura, Hargreaves, Hicks. It's, with respect, the tribunal's gone a bit out on a limb here, not anchored its discussion in any authorities, and come up with some quite surprising propositions of law. And the end result is that due to doesn't mean factual causation. It means something else, but who knows what. In my submission, this court can be confident that Section 1185 is simply a definition of careless. It was not intended to change the law in relation to a need for factual causation. Everyone was clear that there was a test of factual causation, even HMRC in the consultation documents, and frankly, when you move away from that, what are you left with? And this idea of a connection or a nexus, I mean, there's a whole body of case law dedicated to considering what connection means when it arises in the various sections where Parliament explicitly uses that term. I recently did a case called Marlborough, and we spent a day and a half in the Court of Appeal debating what in connection with means. And the authorities there say, well, it's a protean phrase, and you give it content based on its context, and it can mean a variety of different things. If Parliament wanted that sort of test, it could have said connection. It would not, as my Lord said, have misled everyone in Section 36 was by saying, well, we need to know whether the loss of tax was brought about carelessly. And then on my learned friend's submission, define that out of relevance. And my Lord's point about not mixing up the legal question of what the test is with the evidential questions of how you discharge, it's a very important one, because my learned friend raises concerns about HMRC having to prove, or potentially having to prove, difficult things with evidence. But that's not a reason to distort the test, because on my learned friend's own case, even if the taxpayer can prove positively, let's say the evidential burden is shifted. The taxpayer positively proves this carelessness did not bring about that loss of tax. HMRC say and accept, we don't care, you should still find that the extended time limit applies, you should still find the loss of tax was brought about carelessly. So in my opinion, in the draw example, as I kept referring to yesterday, even though we know that if you had read the opinion, it would have supported your tax return, made the loss of tax more likely, they still have to say, well, you should treat that as bringing it about, and the carelessness bringing about the loss of tax. And that can't be right. Again, whatever difficulties there are for HMRC can be taken into account once you've decided what the test is, in terms of what threshold and how the tribunal reacts to that. And you saw in Altunis that the tribunal takes a very practical approach to that. It's not blind to these issues. But you should not rule out, in my respectful submission, the ability for a taxpayer to positively prove this did not cause the loss of tax.
Thank you.
There was then discussion as to, well, does this matter in this case? And in my submission, yes. And if we, the way this arose in the the First Tier Tribunal, it was a pleading issue because HMRC did not plead any case on causation. That remains the case.
Well, except you've got no ground of appeal about absence of pleading.
My lord, at the end of my skeleton, the ground of appeal is the wrong test was applied in the Upper Tribunal. And
Exactly.
The very, well, 131,
It
my
would be a
lord.
distinct ground of appeal to say there never was any pleaded case.
Well, my lord, the issue on the pleading follows from the issue on the test. If you look, please, at the Upper Tribunal decision. At 130, paragraph 130. So that was the pleading. And you can see in the pleading no reference to causation, just asserts carelessness. At 136, the Upper Tribunal upholds the FT's decision that there was a sufficient pleading on the issue of carelessness, but at 136 you say the complaint that HMRC did not particularise the issue of causation is best addressed in the context of the argument the FTT erred in finding that Mainpay's carelessness brought about loss of tax. We deal with it under
Yes, but you do not have permission to appeal to this court on the ground that there was no pleading of causation and therefore HMRC failed in limine.
My lord, there was no error in the... Well, the Upper Tribunal dealt with this by saying at the end, at 162, we don't need to deal with that issue because of what we found the test is. And at the end of my skeleton argument, we say very clearly, this point's maintained. In circumstances, this is 131 of my skeleton argument, in circumstances where HMRC neither pleaded nor sought to prove a case, that the alleged carelessness was the factual cause of loss, appeal should be allowed, or, for any reason that's not the correct outcome, remit to the FTT.
So, can we see where in your grounds of appeal this is pleaded? Because at the moment, I'm struggling to find it. If we look at core bundle, page 14, which is your grounds of appeal, we're on 1.3, applying the wrong test to determine whether carelessness stroke a failure to take reasonable care brought about the alleged loss of tax. Now that seems to me to be perfectly clear. What that's saying is FTT and therefore the UT made an error of law in that respect. There is no ground of appeal saying HMRC never pleaded any case of causation, therefore they fail in limine, and the FTT was wrong to decide otherwise.
My lord, that's the direct consequence of you, if the court agrees with ground 3. If you please go back to my skeleton argument even earlier, paragraph 9, specifically says ground 3 raises the question of whether to what extent HMRC need to plead and establish causation. So the Upper Tribunal's logic was the test doesn't require causation, therefore you can't really have a problem with the pleading. The error of law in that sequence is the first step. And that's why the whole ground of appeal is directed at the first step. The consequence is, if they've got that bit wrong, then they've not dealt with the pleading issue, because the only way they get to avoid dealing with the pleading issue is by saying, well, that's not part of the test, my lord. But look, if in my respectful submission, the point is clear and made in my skeleton argument at least twice, and that's been the whole basis for this ground of appeal, that even if that's wrong, then my submission that it would follow that the wrong test has been applied and should be remitted. And on that point, there was a repeated reference to 2013, and I have to object on behalf of my clients to suggestions that were made as to what happened in 2013. It was suggested that in 2013 we received advice and made a choice not to have an overarching contract. And that is not that's not a point that's ever been raised by HMRC. It's not a finding of fact by the FTT. On the contrary, what happened in 2013 is we took advice from Brabner's. They confirmed to us this was an overarching contract. In fact, we were following what we believed was HMRC's advice, because HMRC's manual said if the employer has an obligation to provide 336 hours, then that's what's enough on the employer's side. And then we put that in our contract. And then we put in a contract to consider, the duty to consider. There was no choice. And there's no finding of fact that we had advice and we chose not to follow it. The opposite is true. But if there's any doubt about that, if this issue now is live because the FTT has applied the wrong test, then it has to be remitted, subject to my pleading point. It's not fair. It's really not fair to my client to have aspersions cast on their behaviour in 2013 without there ever being an issue, because HMRC said we didn't need to go there, and then to arise in this court. So on behalf of my clients, if that is a live issue, because the pleading issue for some reason isn't relevant in this court, then it has to be remitted. And that's important because it goes directly then to the question of causation, because I was somewhat puzzled as to how what happened in 2013 supported HMRC's case. It was put that it did, but I couldn't understand, because in 2013, as I said, we took advice from Brabner's, we came up with a contract, it gets close, but not quite close enough, accept that now. But at no point did we make any choice not to follow advice. And so therefore, what actually happened in 2013 shows that even if we had taken advice earlier, it wouldn't have made any difference. And there's certainly no basis for saying otherwise. So my respectful submission at this point is if you're with me as to what the test is, and therefore there's been an error, there is no finding in either the FTT decision or the Upper Tribunal decision that if we had taken the reasonable steps, the loss of tax would have been avoided. There is no finding to that effect. What the FTT does say, which has been shown at 213, I think it is that so it's FTT 213, it is, in our view, clear that the failure to take reasonable care to ensure that the contract in question was an overarching contract of employment led directly to the loss of tax. But that does not consider and does not find that if we had taken reasonable care, the reasonable care would have resulted in a different tax outcome. It sort of actually assumes that it would even be possible, that the advice would have said it's possible, the advice would have been correct, and would have actually resulted in a difference in the return. As I said, there is no finding that if we had taken reasonable care in relation to trying to ensure that contract was an overarching contract, we would have had any different tax result. In fact, the 2013 situation, which I thought was where at that point was going, proves the opposite. And that was actually my case in the Upper Tribunal. I pointed it out. I said, look, we know what happened when we did take proper advice, see 2013. We fell short, still. But I would draw your attention back to magic carpets and the very pertinent and correct point there made by Judge Greenbank. I showed it to you yesterday. I'll give you a reference. I won't take you there. Paragraph 93, page 1513. And what Judge Greenbank says there, which I showed you yesterday, is that the careless implementation of a tax scheme doesn't bring about any loss. It's only when you get to the tax return and complete that in a particular way, that's what brings about the loss of tax. And therefore, that's the point in time, that's the target. So it's actually no good saying, well, the advice you took in advance of doing these things was inadequate. The real point is, in relation to the tax return, that's containing the loss of tax. How was that a failure to take reasonable care in relation to that entry of that tax return, and what would have happened if you had taken reasonable care? And no answer to that at all. So you have my submissions there. First of all, there was no pleading. My learned friend confirmed that. And she's explained why, and we've heard that. It would be odd if, in my submission, if that didn't result in the outcome, but if it doesn't, then the only fair thing is to remit. Because the wrong test has been applied, this court can't apply it. Unless there's any questions on causation, I'll deal as briefly as I can with grounds 1 and 2.
Thank you.
Ground 1. In my submission, the issue is about identifying the right question and applying the right body of law to answer that question. And you have a waterfall. You have the contract law at the top that tells you whether there's a contract, and if so, how many contracts. Then you have employment law, which tells you whether you've got employment and for what periods you've got employment. And then below that, you've got the tax law, which says, well, for the periods when there is employment, apply a TEPA. And you go down the waterfall in that sequence. HMRC's case, as I understand it, is, well, yes, you apply contract law, but if then when you're getting to the employment law stage, you find that you've got a contract that shifts between being employment and not being employment, we don't like that result. Let's go back to the contract stage and now split it up. So now we've got a frame, instead of having a single contract, we've got a framework contract with contracts for each assignment. Well, I've shown you Cobalt and the multiple authorities referred to therein. When you want to know the answer to the question of whether there's one contract or multiple contracts, it's contract law principles. You don't answer that question by reference to the employment law consequences. And HMRC, with respect, did not identify any authority at all for the proposition that if, under contract law principles, you end up with a single contract covering multiple assignments, even if there's not sufficient mutuality in the gap, you can somehow revisit the contract law question and say, well, actually, it's a framework contract and multiple assignment contracts. None at all. On the contrary, I would respectfully say that's antithetical to what the Supreme Court was saying in Cobalt. I showed you yesterday, paragraph 130, Cobalt, Supreme Court, expressly says, at the end of that paragraph, you first start with the contract, work out what the implications are in terms of obligations and rights. Last stage, you apply the statute. Same applies in relation to employment in the waterfall. And with respect, that's the high point of my case, not Reed. Could I just show you in terms of freedom to contract? It's just in my skeleton, paragraph 27, so you will have already seen it. But may I just ask you to remind us, you can do it now, or we can do it when obviously the court's considering its judgment. But paragraph 27 cites a couple of...
We're looking at your skeleton argument.
My Court of Appeal skeleton, because it cites the relevant passages rather than shifting through a very large bundle.
Yeah, we have it.
You can see in the quoted paragraphs 143 and 144, Mr. Rabinowitz made a powerful submission that HMRC's contention the variation issue is contrary to the principle of party autonomy, on which the common law of contract is founded. Statutes may impose a rule which operates regardless of the intention of the parties, because Parliament may have a reason to impose it, but the common law of contract facilitates rather than frustrates the intention of the parties, except whether what they do is contrary to public policy. It could not be suggested that agreement that a particular alteration should operate as a variation is contrary to public policy. In general terms, we agree with this. Freedom of contract is a basic principle of common law. See Morris and Barron, and also see Cumbria. And so that's my point. My learner friend made a submission, well, look at these cases. They say there's nothing repugnant about having a number of different contracts, one for each assignment. Totally agree with that. Never disputed that. My submission is equally, there's nothing repugnant about having a single contract that covers multiple assignments, even if in the gap does not there's not sufficient mutuality of obligation. And there was an interesting discussion yesterday. Well, is it conceptually possible to have a single contract that sometimes satisfies the employment test and sometimes doesn't? Well, in the waterfall, of course it is, because you've already answered the contractual question at stage 1, and the employment question only comes in once you've answered that question. It doesn't revisit it. My other friend began by saying, well, it's not inconceivable, but then seemed to change her mind. But the point is, if it's conceptually possible, then the FTT in this case, with respect, was wrong at 148. Because it concluded, well, once we've concluded this is not an open...
So where we got to in Ms. Chowdhury's submissions on that point was that she submitted it was conceptually possible as a matter of abstract contract law, but not possible as a matter of employment law. And you, of course, take issue with that because effectively you're saying, well, contract law trumps employment law. But the argument against you is, well, no, it doesn't.
Well,
because this is a question of employment law.
Well, the question of how many contracts there are must be a question of contract law. And if I've shown you...
Yeah, but the question is not how many contracts there are. The question is how many contracts of service there are.
Well, but you can't have a different answer to the number of contracts when you're asking that question as compared to when you're asking the contract law question.
Yeah, well, that's the issue.
Well, my lord, I've shown you. You can see in the passages I've just cited in Cobalt, even the Supreme Court there saying, well, no, employment law defers to contract law. And when I showed you Cumbria yesterday, that's exactly what Cumbria said. So in my submission, it's clear. There's actually no doubt about that. Employment law applies to whatever the contractual position is, but you've got my submission. In terms of this idea of shifting status, well, it's clear that a contract must be able to shift status, applying the very reasoning in Cobalt, because you could have a contract that absolutely is an overarching contract of employment. Let's assume that. And then the parties, by variation, reduce the obligations in the gaps, so that now they don't satisfy that threshold. Cobalt tells us that is the same contract because you've used a variation. That's what Cobalt tells us. So it did satisfy it, but then you varied it. Now it doesn't satisfy the test in the gaps. It is no longer an overarching contract of employment. But Cobalt tells us it is the same contract because you've used the mechanism of variation rather than rescission of the new contract, and therefore it must be possible. And conversely, it must be possible to go back the other way. You have a contract that's not overarching contract of employment, and then you vary it, and now it is, because you've added obligations in the gaps. Cobalt tells us if you've used the mechanism of variation, that is the same contract, and so it must be possible. We don't need the pension example. That's clear enough in my submission. HMRC seem to me to have two main submissions. First is that there's nothing repugnant about having separate contracts. I've dealt with that. I'm not saying there is. And the second was, well, look at the employment law cases. None of those refer to the possibility I'm talking about. But with respect, HMRC did not establish in any of those cases that it would have been relevant for the court to consider whether a single contract can cover multiple assignments without there being sufficient mutuality in the gaps. In Nethermere, the question was whether they were employees at all for the purposes of unfair dismissal. In McMeehan, the question was whether they were an employee at all, so they could claim money owed by an insolvent employer from the Secretary of State. In Clark, were they an employee so they could bring an unfair dismissal claim? In Quashie, again, were they an employee so they could claim unfair dismissal? It would not be relevant in any of those cases to look at the issue we've been looking at. Similarly, in the PGML case, the question was whether the referees were employees at all. HMRC said they were, PGML said they weren't. That was the issue. Yes, it was looked at through two different lenses, but the issue we're looking at didn't arise. And it's trite that you cannot take authorities that do not raise an issue, do not consider it, it's not argued, and do not decide it. And if you need, the court doesn't need authority for that, but if you want to see some authority for that, in the FCA case we looked at yesterday, I'll give you the reference, I won't take you there, 1338, paragraph 305, makes the point that the decision and reasoning of a court is framed by the arguments it makes. And I think that leaves us only with the consequences under ground 1. My learned friends seem to say it'd be odd, surprising, or not even possible to have different employments with different persons ongoing at the same time, because she was worried about what was happening in the gaps. Maybe you were employed by someone else. With respect, I don't understand that point. You plainly can be employed by multiple employers for the same periods. A student may have a job at the newsagents in the morning and a job at the bar at night. It's very common. So there's no issue there. In terms of havoc, well, none was identified. And there was a suggestion, well, it's odd for a contract to change its status. In my submission, no, it's not. In any event, that wouldn't be a good guide to what the correct answer is. I've given you an example of varying a contract so that it does actually shift between the two categorizations. I think the final point is this idea that Section 4 only applies if the contract is at all times a contract of employment. In my submission, it would be wholly wrong to interpret Section 4 in that way. I've given you my variation example. It would be open to abuse. If you have to be able to say this contract was at all times a contract of employment to fall within Section 4, you open up all sorts of potential for abuse, because then parties will deliberately structure it so that it was not at all times a contract of employment, and then say it doesn't fall within Section 4. In my submission, Section 4 quite clearly is referring to the periods when it is a contract of employment, and there's no difficulty in interpreting it that way. Unless there's any questions on ground 1, I've got ground 2. I'll deal with briefly.
Thank you.
My learned friend raised an argument, well, the FTT has found that this was not a genuine attempt to reimburse subsistence expenses. With respect, he's looking at the wrong side of the coin there. There's two issues in this sort of case. One is the money that, if any, the money that the employer gives the employee in relation to the expense. The employer doesn't have to give them anything. The point being discussed at 190 to 193, and in the Cheshire case on which that's based, CFTT 176, is that if you can show that your reimbursement scheme is a genuine attempt to reimburse no more than the expenditure, the deductible expenditure incurred by the employee, it may not be a profit of employment at all. That was the point in Cheshire. If that scheme in Cheshire was a genuine attempt to reimburse the employees, the money handed over to the employer was not earnings. That is an entirely different point to deductibility. Even if you have no scheme to reimburse your employees for their expenditure, you can still, or the employee can still, through their PAYE forms, deduct the expenditure incurred. It's not in any way tied to reimbursement. And deduction is not based upon whether there's a scheme for reimbursement that's a genuine attempt to reimburse. There may be no scheme at all. Deduction is only looking at the number you have sought to deduct and whether it satisfied the separate legislation, 338, 339, for deducting expenditure, which is an entirely separate question. And in relation to that question, there is absolutely no subjective question of, well, was there some subjective intention to reimburse genuine expenditure? It doesn't arise, because this is not 338 and 339 are not concerned with reimbursement at all. So that question does not arise at all in this case. The only relevance is where you're trying to say the money reimbursed was not earnings from employment in the first place. And we don't say that, which means that yes, the money handed over by Mainpay to these workers was earnings. No one's disputing that. The separate question is, have we got a deduction for the expenditure incurred? That's what this case is about. Two separate issues. There was then a submission as to reliance upon the numbers in the brief. And Mr. McGee's submission was that, well, if you don't go through this mechanism and you don't satisfy these checks and safeguards, you can't rely on those numbers. But with respect, if we actually look at what the checks and safeguards are, there really aren't any. Supplemental bundle, page 3, please. Travel must be, so this is the qualifying conditions, bullet points 1, 2, and 3. Travel must be in performance of the duties or to a temporary place of work. Well, that's just the legal test for deduction at all, not a check or balance. Should be absent for a continuous period in excess of 5 or 10 hours, and the employee should have incurred a cost. But in terms of whether the numbers that we've seen in this brief do or do not relate to the actual expenditure likely to have been incurred by the employee, there's nothing. That's not what this is doing. And my only point is on this, these numbers here on the previous page are reasonable numbers to estimate the expenditure incurred by someone who does incur expenditure. That's as far as it goes. And HMRC has never said, as far as I'm aware, they are not reasonable numbers for that purpose. Indeed, you can see at FTT paragraph 180 that HMRC's own practice, well, this is a point I made in the FTT, HMRC's own practice was that if you paid over, if an employer paid over the amount in the scale rates, HMRC would only assess the excess. And so that rather confirms that these are reasonable estimates. And the importance of reasonable estimates is very large. You've seen in my skeleton argument in paragraph 68, reference to the Supreme Court in the Lothian case, except it's a different context, but saying that proof by estimates is open in all cases. Which means that there's no rule of law that blocks us from using reasonable estimates. Indeed, it's not even a question of tax law, if I may respectfully say so. It's a question of the law of evidence. Because ultimately, if the taxpayer puts a number in the tax return, HMRC dispute that number, where does it end up? It ends up in the FTT. What does the FTT do? It applies the normal rules of evidence and decides on the balance of probabilities. And there's no reason for applying a different test at that stage as compared to the tax return. And so yes, the burden is on the taxpayer to prove on the balance of probabilities. And yes, the absence of the primary evidence could count against you. It doesn't mean it will count against you. The court knows the case law in relation to adverse inferences based on absence of evidence. And there is no rule of law that you can't seek to prove the figure in your tax return by use of a reasonable estimate on the balance of probabilities. On the contrary, I referred you to the Supreme Court saying that proof by estimates is open in all cases, not just cases where the absence of the primary evidence is not due to your fault. And if I may end by saying that such an approach, saying that you can only learn a reasonable estimate where the absence of the primary evidence is not due to your fault, caused quite considerable concern on my side, not Mainpay, but their advisors, because in their experience, numerous HMRC investigations are concluded on the basis of reasonable estimates. And if it turns out to be the law that when you can't use reasonable estimates unless the absence of the primary evidence is not due to the fault of the taxpayer, well, then that could be a problem for both HMRC and taxpayers. Unless the court has any questions, those are submissions in reply.
No, thank you very much. Very, very helpful, Mr. Birth. Well, thank you all very much indeed, Mr. Chowdhury, Mr. McGee, and you. Sorry, were you?
Sorry, my lady. I'm reminded that there is one minor admin point, which is we understand that the Court of Appeal now asks for a list of individuals to
I'm good to deal with that. Yes, yes.
Right. I was going to say we have our list ready.
Good. If it could be sent through to my clerk. Yes. Just to explain for anyone that doesn't understand that cryptic conversation. You won't be surprised to hear that we are going to reserve our judgments in this very important matter. You'll be sent a draft of our judgments in the first instance. That's obviously for typographical and minor infelicities only, and not as an opportunity to re-argue the case. And we'd hope that any other matters can be dealt with in writing, and that ultimately you'll be able to agree an ultimate order. We'll deal with any disputes on paper. You will note that the draft will have the terms of the embargo at the top of the draft, which we take extremely seriously. Some cases it really doesn't take matters much further, but in a case like this it is very important, and I'm grateful, Ms Chowdhury, you've already said you will send your list. That is because it is very important that only those people who it is absolutely essential should see the draft, see it, because there is a danger otherwise that unfinished orders and drafts that have not been finalised and don't represent the court's final judgment are distributed or dissipated throughout business or other communities. So I'm grateful, obviously, Ms Chowdhury, you've already taken instructions about it. No doubt Mr Firth, you'll explain to your solicitors and lay clients that that is the position.
My lady, yes, of course. I don't have solicitors. It's been independent tax who've instructed in the upper tier and the first tier, but they're not solicitors. They can't instruct the Court of Appeal. But nevertheless, I think it would be highly relevant for at least one or two individuals within independent tax to see the draft at the draft stage on the basis they will understand the confidentiality. So I'm not going to ask you to decide it now, but if I can put in my list in the next one or two individuals.
No, we wouldn't normally expect the list until after the hearing in any event.
Great.
So, but as long as those people understand
yes.
The importance of the embargo, and
yes.
breach of it can amount to a contempt of court.
Yes, my lady.
But I'm sure you'll explain that to them.
I will, my lady.
Yes. Now, is there anything else that we need to deal with today?
My lady, only the email address for your clerk in order to pass.
The usher will give you that. But
Thank you very much.
Very well. Thank you all very much for all the hard work that's gone into the preparation of this.